Okay, imagine this. You've put years, maybe even decades, of work, real innovation, just sheer grit into creating something new.
Uh,
You protect it with a patent application, it finally gets accepted. And then, maybe because of an admin slip-up, something totally understandable like a mistake during, say, the COVID chaos.
right.
A critical deadline for publishing that acceptance gets missed.
Oh boy.
And just like that, the future of your invention, the patent rights you worked so hard for, they're just hanging precariously in the balance.
Yeah, that's a scenario that would send shivers down the spine of any innovator, any business really, that relies on IP. Patent systems, look, they rightly have strict deadlines.
Sure, they need certainty.
Exactly, certainty for everyone involved. But what happens when a deadline is missed? Even if it's a genuine error, does the system have any built-in flexibility, any room for discretion to maybe grant a second chance?
That question, that's exactly what we're diving into today. We're going to explore the, well, sometimes complex landscape of South African patent deadlines, and crucially, when and how the system can allow for some grace, some discretion, to potentially save your patent rights even after a deadline has technically passed.
And our guide for this deep dive is a specific, actually pretty significant High Court judgment from South Africa. It was handed down in August 2023.
Which case is that?
The case is Mu Mecanicos Unidos S.A.S, the Registrar of Patents. We'll be pulling the key insights right from the court's decision and some related materials you've shared.
Okay, so our mission today is clear. We want to break down this judgment, unpack these sources, and really understand what happens when a key patent deadline specifically for publishing acceptance is missed in South Africa.
Right.
We want to figure out if the authority, the Registrar of Patents, actually has the legal power to grant extensions after the deadline has flown by.
And why this particular case cuts through some of that previous uncertainty, giving us a pretty definitive answer.
Exactly. Think of this as your shortcut to understanding a critical aspect of patent law, one that could genuinely be a lifeline when you most need it.
So let's start by setting the scene. Let's look at the specific situation Mu Mecanicos found themselves in. This case, it all centered around their South African patent application, number 20-2005-41 SANEM.
Okay, and the timeline here is really important, isn't it?
Crucial. The application was formally accepted by the Registrar of Patents on July 5, 2021. Now, the Patents Act has a rule.
Yes.
Once an application is accepted, the notice of that acceptance must be published in the official patent journal within a specific time frame.
And that time frame is?
3 months. 3 months from the date of acceptance. So for Mu Mecanicos, it accepted July 5th, 2021. That notice needed to be published by September 29, 2021.
September 29th. Okay. And here's where the trouble started, I assume.
You got it. The notice for publication, it didn't make it by that September deadline.
Oh.
It was only submitted on October 18, 2021, and the actual publication happened on October 27, 2021.
So well after the 3-month period has ended.
Clearly after, yeah.
And what was the reason given for this delay?
Well, the reason presented to the court was an administrative error by the company's previous attorneys. Their erstwhile attorneys, as the judgment puts it.
Okay.
They explained this oversight happened during, the challenging circumstances of the COVID lockdown period.
Right. Understandable context. So what happened then?
Well, it was Mu Mecanicos' new attorneys, Spohr and Fisher, who later discovered the missed deadline.
Okay.
And realizing the potential consequences, a patent application could be deemed lapsed if this isn't done right. They acted quickly. They applied to the Registrar of Patents for an extension of time to essentially, fix the issue and get that notice published retroactively almost.
So they asked for an extension after the deadline had passed.
Exactly.
Yeah.
And now, faced with this request for a post-deadline extension, the Registrar of Patents made a decision on May 10th, 2023.
And let me guess. They didn't grant it.
They refused the request.
Yeah.
Correct.
Okay, and their reasoning. This is central to the whole thing, right?
Yeah, absolutely. The registrar relied heavily on an earlier court judgment, the University of Pretoria v. Registrar of Patents case.
Ah.
They interpreted the relevant parts of the law here, that's Section 42 of the Patents Act, read with Regulation 46 as containing what they call peremptory language.
Peremptory language. What does that mean in plain English?
It basically means the law is absolute, mandatory. It leaves no room for exceptions or discretion. The registrar, leaning on that University of Pretoria case, believed this language meant any request for an extension had to be made before the original 3-month period ran out.
So even if you had a good reason,
Well, they mentioned needing good cause and paying a fee, but the absolute critical point for them, their stumbling block, was the timing. Asking after the deadline meant, in their view, they simply lacked the power to grant it. End of story.
Wow. Okay, so Mu Mecanicos didn't just accept that.
No, they challenged the refusal. They took the registrar's decision on appeal to the High Court.
And did the registrar fight the appeal?
Interestingly, no. The registrar chose not to oppose the appeal.
Okay. And on appeal, did anything else happen? Was there new information?
Yes, actually. Mu Mecanicos also asked the court for permission to introduce some new evidence. There are legal provisions for this.
Right.
And this new evidence was important. It gave more detail explaining why the original attorneys missed the deadline. And critically, it pointed out that Mu Mecanicos hadn't really had a full chance to present this detailed explanation to the registrar when they first asked for the extension.
Ah, so they wanted the court to have the full picture.
Exactly. And the court agreed. They found it was in the interest of justice to allow this further evidence. I mean, how can you properly assess a request based on good cause if you haven't heard the full story behind the delay, right?
It makes sense. So this brings us to the absolute core legal question the High Court had to wrestle with. This is the key takeaway for you, the listener.
Right. The court's central job was to figure out whether, when you really look at Section 42.3 about publication, together with Regulation 46, does the law actually allow an extension for that publication period to be granted after the original 3 months are up?
Does the registrar have the power to give that second chance in this specific scenario?
That was the million-dollar question. And to answer it, the court had to look at the registrar's general discretionary powers found elsewhere in the Act, specifically Section 16.
Section 16.
And even more specifically, subsection 16.2.
Okay, Section 16.2, what does it say? Why is it so crucial?
It's incredibly important because it gives the registrar a pretty broad power. It states they may, save where it is otherwise expressly provided, extend the time either before or after its expiry.
Okay, hold on. Before or after its expiry?
Yeah.
And save where it is otherwise expressly provided.
Those are the magic words. That general power seems to allow extensions even after a deadline is missed.
Unless
Some other specific part of the Act expressly says, nope, not in this case.
Okay, and this is where those different court cases started clashing, right? Because people interpreted this interaction differently before.
Exactly right. The University of Pretoria case, the one the registrar leaned on.
Yes.
That court had found that the wording for a different deadline, the acceptance deadline in Section 40, was peremptory, meaning no extensions after it lapsed.
Okay.
And crucially, the University Court also mentioned in passing, it was in paragraph 59, that the wording in our section, Section 42 for publication, was similar. They suggested it also limited the registrar's power, meaning requests had to be made before the 3 months were up.
So that view basically slammed the door shut on post-expiry extensions for publication.
Pretty much.
Yeah.
But then you have the Trusco case. This was a decision from the Supreme Court of Appeal, which is a higher court.
Okay, so potentially carries more weight.
Definitely. And Trusco took a different stance. It firmly established that the registrar does have this general discretion under S16.2 to grant extensions. And they can do it either before or after the time limit expires. That power is only taken away if another provision in the Act expressly inhibits it. It needs that explicit override language.
The otherwise expressly provided bit.
Precisely. And Trusco also strongly reinforced a fundamental legal point.
Yeah.
Regulations, like Regulation 46 in our case, or Regulation 83, which was relevant in Trusco itself.
Yeah.
They can't override the clear provisions of the Act. The Act itself is supreme. Regulations are subordinate.
Okay, that seems like a clear principle. Did the Mu Mecanicos court look at any other cases?
They did. They briefly mentioned the Kaltenbach approach, which came before Trusco. That approach had taken a more restrictive view of the registrar's power.
The view the Mu Mecanicos court disagreed with.
Yes. They found that restrictive view problematic. It could lead to really harsh, unfair results for patent holders because of genuine, honest mistakes, bona fide errors, as the law calls them, especially if those mistakes were made by their attorneys or agents.
Like in this case?
Exactly. And they also referenced the Busby case. Now, Busby dealt with different regulations, but it supported the general idea that the registrar can consider extensions outside deadlines and that regulations don't trump the Act.
Okay.
Busby kind of highlighted the registrar's role as more procedural and that it's generally in the public interest to let parties fully argue their case rather than getting shut down on a technicality.
Makes sense. Avoiding form over substance.
Right. And they even looked way back at the older Sparklets case from the 1916 Patents Act era. just showing that this whole debate about whether specific sections kill the general extension power has deep historical roots.
And what did Sparklets find?
Interestingly, in Sparklets, the court did find that the specific section they were looking at back then did contain that explicit, otherwise expressly provided type wording. So in that specific historical context, the general discretion was excluded.
Okay, so context matters. The specific wording matters.
Hugely. Yeah. So the Mu Mecanicos court, Judge Kuverji, carefully weighed all these different cases, these interpretations, these legal arguments.
And the finding, the big reveal.
The finding was decisive. The court sided with the principle laid down by the higher court in Trusco. Meaning the core finding is this. Section 42.3. The rule about publishing acceptance within 3 months, it does not contain that crucial otherwise express wording. The wording that Section 16.2 says is required to actually remove or prevent the registrar from using their general power to grant an extension after the 3-month period has passed.
So the power does exist for this publication deadline, even after expiry.
That's the conclusion. The court emphasized that adopting that narrow, restrictive interpretation would just be unfair, prejudicial to patent holders who suffer delays through no real fault of their own, like the administrative error here.
Right.
They saw the registrar's power under S16 as a procedural safeguard, really, something that serves the public interest by allowing patent rights to be fully considered, not just tossed aside on a timing issue. Any
mention of broader principles?
Yes, they noted it aligns with constitutional principles, promoting access to justice, fair process. But, and this is important, they stress that getting an extension isn't automatic. It's not just there for the taking.
Okay.
The registrar still has to exercise their discretion fairly, judicially, meaning like a judge would, considering all the facts properly and thinking about the rights of everyone involved. Even if, like here, the appeal wasn't opposed. S16.1 sort of implies that duty.
Right, it's a power, not an obligation to grant it every time. So after all that legal deep dive, what was the practical outcome for Mu Mecanicos? And more importantly, what does it mean for you, our listener?
Well, the court's final order was clear. They overturned the registrar's refusal. That decision was set aside.
And the extension.
The request for the extension of time for publication was granted.
Fantastic news for them. So summarizing the takeaway.
The key takeaway from the judgment and the materials we looked at is that the Mu Mecanicos case confirms, even if that required publication of acceptance happens after the strict 3-month deadline.
Which technically means the application is deemed lapsed.
Right. Even then, it is legally possible to get an extension of time for that publication after the lapsing has occurred.
And how does that happen again?
It happens through the registrar using their general discretion, that power under Section 16.2, to essentially fix the lapsing, to rectify the situation and bring the application back to life.
But you still need a good reason.
Absolutely. It's not a free pass. You still have to show good cause for the delay, explain why it happened, and the required fee still needs to be paid.
Got it. So why is this case so important for anyone listening who's involved with or just interested in patents in South Africa?
It provides a really vital potential lifeline. It shows that while meeting deadlines is, yes, absolutely essential. Critical, yes. But the South African patent system does have a mechanism that registrars general power under Section 16.2 to potentially salvage patent rights that might have been lost due to genuine mistakes, even after the deadline has whooshed past.
It basically clarifies that the door for asking for help after the deadline isn't automatically slammed shut.
Exactly. Not unless the specific law for that particular deadline explicitly says no post-expiry extensions allowed here.
And this judgment confirms that the broader, more flexible view from the higher court, from Trusco, applies to this really crucial publication deadline. It overrides that older, more restrictive interpretation the registrar had relied on.
Correct. So yeah, this deep dive has really shown us that a key South African court case has affirmed this power. The power to extend a patent publication deadline exists even after it's been missed.
And it's all based on the proper reading of the Patents Act and understanding the scope of the registrar's general discretion.
It's a powerful confirmation, really, that while rules give necessary structure, the system does allow for fairness and potentially that second chance when genuine errors happen. It stops valuable innovation being lost just due to, procedural slips.
Definitely a positive outcome for innovators.
For sure. However, while this case gives crucial clarity, it provides a path forward for patentees who missed that publication deadline. It still hangs entirely on demonstrating good cause for the delay.
Right. It's not automatic.
Not at all. And what exactly counts as good cause? Well, that's something the registrar has to decide case by case. They have to use their discretion fairly judiciously based on the specific facts presented to them.
So that leaves us with something to think about, doesn't it? How does navigating this balance, demanding strict adherence to deadlines on one side, but then allowing for this discretionary relief based on individual circumstances on the other, how does that ultimately shape the reliability and the fairness of the patent system for everyone involved?
That's a great question. It's definitely something to mull over as you engage with the world of patents. Finding that sweet spot between certainty and flexibility is always a challenge.